What happens when a judge discovers that the very document charging a defendant may be written incorrectly? In this courtroom showdown, a routine felony case suddenly takes an unexpected turn as the judge questions the indictment itself, challenges the prosecution, and refuses a defendant's request for a new attorney. Stay until the end to see why the entire case may need to be refiled and what that could mean for the defendant's future.
Thank you. Good work. It'll relax. Relax is doing all the damn duties, right?
Not bad. Hey,
It's taking over.
I'm
That's right. Are you Jesse Mason, sir?
Yes, sir.
In 26 CR 446. Hello. Okay. You're charged with the state jail felony of unauthorized absence from a community correction facility. Was this one of those things where he was released for visitation or something? And intentionally left the center as intentionally or knowingly leave said center as directed by the court and the community supervisor, and without the accomplice criminal second order. Right. What? It's been in there while he was required as a condition of community supervision. Required as a condition of community supervision, required as a condition of correctional programming. I don't know, that doesn't make sense. To submit to a period of detention and treatment in a community correctional facility, namely Beaumont Center. And you intentionally or knowingly left said center as directed by the court and the community supervision correctional. That doesn't make any sense. And without the approval. So it says that he intentionally or knowingly left said center.
Judge, I agree that
I'm just reading the indictment.
yes, I agree that the wording is interesting and the facts on this are a bit unique. I believe that the indictment is alleging that he was supposed to be in the center as directed by the court and community supervision, and without approval of the court and community supervision, he left the center.
Well, that's not the way it reads.
Yes, we can.
Intentionally or knowingly leave said center as directed by the court. I didn't direct him to leave.
No, Judge, we can get that fixed.
Yeah, the wording's bad on this, sir. We're trying to. First thing is, it doesn't matter until the indictment is fixed. That's the most important thing. Everything flows down from the allegation, and the allegations. It's alleging up at the unauthorized absence, but the body is confusing and it needs to get cleared.
Yes, Judge, we will go right on that.
The thing is, you've got those 3 prior convictions in January of 22 for out of Gregg County, which are terrible things. This is a state jail felony, but if all of these 3 convictions are true and you're convicted of the correct wording that it was intended based upon the offense as alleged, then this would be a state jail felony, though punished as though it would be a 3rd-degree felony. It gets enhanced 1 level because of the 3 prior convictions. And the thing that helps you on that is that these were 3 convictions on the same date, so you can't stack them because they weren't in sequence of dates. But it's still a state jail felony punished as a 3rd-degree felony, so you're looking at up to 10 years in prison, which is never a good thing, and you're not eligible for probation in front of a jury because these allegations of prior convictions are in the indictment, and if one or more of them were true, that wipes out a probation qualification for you in front of a jury. So that's what I think we're looking at, right, Don?
Yes, Judge.
Okay. She needs to repair the indictment.
Yes.
Can you do that in 1 week?
We can try, Judge.
Well,
I'll get it to intake today, but.
Thank you.
Judge, he's also asking that regardless of be set for trial, that I be relieved so we get to court with him.
You be relieved for what?
That I be relieved.
So he can be pro se?
No, sir. He wants another attorney appointed, so it can be resolved in
No.
a quicker manner.
Don Dusler, I've known Don Dusler my whole career. He's a fine lawyer. You can go hire anybody you want, but I chose him as one of my public defenders because he's competent and he represents his clients. I've known him for 4 years. And but you can hire anybody you want, but you don't get to pick the appointed attorneys. That's not the way it is, sir. Sir, go ahead.
I am requesting another one.
Okay, you're denied. Denied. You are entitled to a competent attorney, and he is one. I haven't heard anything to suggest he's otherwise, or that there's a problem between y'all. That's the way it works. You can understand if it was otherwise. Let's say we have 3 public defenders or 4, and then everybody decides they don't like 3 of them, then one person would end up doing 1,000 cases. That wouldn't work. But they rotate, and sometimes you may disagree with them. But I was a lawyer, private lawyer for a long time, and sometimes people didn't agree with the advice I was giving, but you're entitled to know from legal expertise what you're facing, the pros and cons. At the end of the day, it's not his choice; it's your choice on how you proceed. But you don't get to choose the attorney when it's an attorney that's appointed to represent you. If the attorney didn't do anything inappropriate or unethical, Don doesn't do that. He has a good reputation. Let me just rotate this a week so we know where everybody stands on what the defendant wants to do.
Yes, Judge. We'll get that indictment.
This needs to be, you can correct it.
It'll likely have to be re-indicted.
Yeah, well, that's what they do on Thursdays. Right?
Wednesdays, yes.
Wednesday.
Yeah.
Okay.
I'll do that today.
We'll do this back on Monday week and see where we are on that, okay? And see if there's a way it can be resolved without a trial. And then if he wants a trial, he'll get a trial, and then it's one of the trial lawyers.
Can I speak?
It would be different from him. Yeah, you can speak.
All right. I arrived at the police station to turn myself in because I realized I had made a mistake. I learned that the blue warrant had not been active yet.
Okay, hold on.
And
You're talking about the facts of the case, right?
To the halfway house.
Yeah, hold on. You're talking about the facts of the case. And number one, unless you're going to ask me to be the judge and the jury, you're going to have a jury trial if you want a jury trial. But right now you're talking about facts of the case, and I'm not the fact finder for whether you committed a crime or not. That's not what we're here for today.
I was just trying to tell you.
There's nothing I can do about change. Okay, Sarah, there's nothing I can do about.
Read me my Miranda rights.
Okay, all right. That's something you tell your lawyer, and that's brought up in front of the court or the jury if that isn't part of the element of the crime. But that's not anything that really I can do right now. But that's where you pass all that, then that gets brought up during a trial or doing a pre-trial hearing, and then the court or a jury would make the fact issue determination, and then your life proceeds in that direction. But right now, that's not there's nothing I can really do about what you're saying. First thing is the indictment needs to get corrected.
Yes, Judge.
So that
Get on that.
it's clear. Okay, and then we set 1 week and see where we have gone from there. Okay, sir? All right, thank you. Don, I've got surgery.
This case proves that in court, every word matters. One mistake in a legal document can change the direction of an entire case. What do you think? Was the judge right to stop everything until the indictment was fixed? Share your thoughts in the comments below. If you enjoy real courtroom drama, legal analysis, and fascinating case breakdowns, make sure to like, subscribe, and turn on notifications so you never miss our next video. Thanks for watching, and we'll see you in the next case.